Okay, so good morning, everyone. Today's daf is Baba Kamma daf Kuf Zion. We are already in the top of daf Kuf Zion. We are in the middle of discussing a series of rulings of Rabbah, and we are talking about situations. This is 27a1. We're talking about various situations of things that fall off a roof and cause problems. Okay, and cause damage. And right now we just talked about people falling off the roof. We talked about the first case was a utensil fell off the roof. Another case was a child fell off the roof, God forbid, and was going to fall to his death. And then somebody else comes and kills the child while the child is falling. And we said, what's the story there? So now we're again sixth line on Kaf Zayin Amud Aleph, sixth line on the 27a, and we say V'amar Rabba. Rabba comes another situation. Nafal mirosh hagag v'niska be'isha. So if somebody falls off a roof, and Rashi tells us v'niska. So we'll say it in a moment. Chayav b'dalad dvarim. Sorry. So let's go back. Nafal mirosh hagag. You fall off the roof. V'niska be'isha. He ends up inside the woman. So that basically a very remarkable situation, because it's hard to imagine how this could even potentially happen physically. But on some level, we're dealing with theoretics, and so theoretical possibilities. And so he falls off the roof, and somehow they are engaged in intercourse. So chayav ba'arba dvarim. He's obligated for four things if he's done damage to her, meaning that he's obligated to pay for any reduction in value as a result for her. That's the nezek. He's obligated in the pain and suffering penalty. I'm sorry, the damage that's associated with that. He's for those losses that she has, because obviously she wouldn't ordinarily be willing to accept the damage of being fallen upon. He's obligated to pay for any lost wages that she has, and for any medical bills that she has. So those are the four different things that he would be obligated to pay. But what we usually have five things that somebody is obligated to pay if they injure somebody intentionally, and the fifth one is embarrassment, and for that he would not be obligated to pay. We'll see why in a moment. Uviyimto lo kana. But when it comes to if in addition to this amazing situation, that remarkable situation that would never really happen, if in addition to all that it turned out that his brother had just passed away, and this woman that he fell upon happened to be the widow of the brother who died without any children, and so this man had the opportunity to do yibum with this woman. And usually we say that yibum, it doesn't make a difference why you're having intercourse with the woman. If you have intercourse with the woman, then she is married to the brother. Here, that would not be sufficient. So let's take a look at Rashi. Rashi is going to tell us two important things about this situation. So first of all, Rashi, 3 lines down in the narrow lines, V'niska be'isha chaya b'dal dvarim. If they ended up in an intercourse situation, he would be obligated to pay 4 different things. We're talking about where he fell as a result of a normal wind, meaning the guy was just absolutely not careful enough, and so as a result, that would be the problem. So to have a lay karav lamezid. So as a result, it's almost like he did it on purpose, because he was so negligent that even a common wind would have resulted in it. And so as a result, that's a situation where we're going to say you're not just obligated to pay for the damage that you cause, but you're even obligated to pay for the additional aspects of damage, namely the 3 that we're talking about here. Obviously, you pay for the reduction in value of the person. That's the nezek. But you're also going to have to pay for the pain, for the stoppage of work, and for any kind of doctor bills. So those 3 additional things you'd have to pay for, because this is so negligent that it's almost like you did it on purpose. And then the second Rashi, continuing with the Rashi, ubiyam bamto lo kana, and yet you would not actually have acquired the Yavama as a wife, because because even though when we learned Maseches Yavamos a few Masechtos ago, Hava al Yavamto Bein B'Shogeg Bein B'Mezid, Kana, that it doesn't make a difference whether you come on you have a relations with the Yivama, whether it's intentional or unintentional, you have acquired her as your wife. Hanimili, that those words are only said, you have to at least intend to engage in marital relations. If you don't intend to engage in marital relations, and yet you somehow fall into a situation where you're engaged in marital relations, that would not be levias isha acheres. You have to at least have intended to have relations with somebody. This person didn't have any intention to engage in intercourse. Hilkach lo kana. As a result, there is no acquisition. There's no sense of marriage. And so if one of the other brothers then now comes and does mamar with her, and essentially says, and even mamar is Rashi's point, that even mamar, which is the an act of speaking, it's basically the hareyat mekudeshes li of Yivama, where somebody says, I want to marry you as my Yivama. We say that is that statement is sufficient to make the woman prohibited to the other brothers. So now she can only do Yibum with that brother. And so as a result, if one of the other brothers did that, this man, even though he had had intercourse with her, would no longer be able to marry her at all. Okay, so that's what Rashi says, explaining the situation. And what did we say? So clarifying what are the four things. You're obligated for damage. That's the reduction in value. Tsar, the pain. Ripoy, the doctor bills. B'sheves, and for lack of employment. Aval boshes, low. But the fifth one, which is embarrassment, humiliation, you would not be obligated. Because you're only obligated for the damage of embarrassing somebody when you have some kind of intention. And we'll see that intention is just the intention to inflict injury. You don't have to intend to embarrass the person to be subject to that obligation. You just have to be intending to inflict injury, and you will be obligated to pay for humiliation. So that's the next ruling of Rabbah, and we have another one. Rabbah tells another one. Now distinguishing from our prior case, where the last case, it was a fall in a normal wind. Now we're talking about an abnormal wind. And as a result, the person was fallen upon, was injured and embarrassed. So chayav ala nezek upater daled b'dvarim. But so you're only obligated to pay for the damage. And that's based on the principle that we saw in our Mishnah, that adam muad la'olam. People, human beings, are always responsible for their actions. And so here we're going to say that the person is chayiv for the damage, chayiv for the reduction in value, but they are not going to be liable for the other four. Namely, they're not going to be liable for pain, they're not going to be liable for healing, they're not going to be liable for loss of employment, and they're not going to be liable for embarrassment. So Baruch Matsuya v'hizik uviyesh, and if on the other hand it was a normal wind, well then chayiv ba'arba dvarim upater alaboshes. Well, then you would be obligated for the four different things. Again, nezek, sar, ripoy, and shabes. And so you would not be obligated in boshes. You would be obligated in four of those things, but not in boshes. V'imnis hapech chayiv al haboshes. But if during the course of we'll translate this as the way Rashi does. In fact, I just realized I didn't note that we should take a look in Rashi. What does nishapech mean? So let's take a look in Rashi. It means literally to sort of flip. Im nishapech. This is now the next Rashi that we had already done. The first two Rashis in the narrow lines. This is the third Rashi in the narrow lines. It's right opposite Einu Chayev in the text of the Gemara. Im nishapech la'achar shehiskil linpol. After somebody begins to fall down, he flips. Deniskaven linpol al ha'adam lahanato. That he purposely tries to land on somebody else in order to not hurt himself, in order for his own benefit, so that he's trying to essentially save himself by avoiding the damage that he might have otherwise gotten. If that is what has happened, so even though the fall off the roof was not an intentional act, this act of flipping that was intentional. Tanya, mimashma shenamar v'shalcha yada, that when we have the story, this is a story that's in Dvarim Perakav Hey Pasuk Yud Aleph, talks about two people are fighting, two men are fighting, and the wife of one of them saves her husband by grabbing the other person in a not appropriate place. And so what happens? She's going to have to pay for that humiliation. And what do we say? It says in the pasuk that vishalcha yada v'hechazika, that she reached out her hand and she grabbed him. Now, of course, if she reached out her hand, she grabbed him, because let's take a look in the Gemara. From the fact that it said that she sent out her hand, I wouldn't, of course, no. Wouldn't I know that she had grabbed him? No, of course I would know that. So, so what is it telling us? Why does the pasuk add the extra word of "and she grabbed him"? That you're obligated. So even though she didn't necessarily intend to embarrass the guy, she only intended to injure him to save her husband. So as a result, she's going to still be obligated to pay for the humiliation. Go ahead.
How does one determine the proper amount for humiliation?
So that will be something that we will cover. My recollection is that
win the battle.
What? Oh, yeah. Well, the wife helped him, so he won the battle. Correct. So the answer to your question is we would often the both for the tsar, the pain, and for this, we essentially ask how much would it take to be paid in order to go through this experience, or potentially how much would you pay to avoid the experience. So to have not gone through
your name, so to speak.
Correct. Well, it's not a post facto analysis. It's both of them would be an a priori analysis, meaning if I do something to embarrass you, right, then the question that we ask is we effectively ask the random person on the street either how much would I have to pay to do that embarrassment to the other person, because it's not how much do I have to pay to fix your feelings, because it's for you, it's too difficult to make that judgment. So we're going to ask somebody on the street what their right amount would be. And then, or how much would you, the person on the street, pay to avoid this? If I tell you I'm going to do the exact same thing that I did to Stan, how much would you pay in order to avoid it? They say, okay, I'll pay $500 to avoid that. Well, then I pay you $500. So, okay, so that's the idea is to try and come up with a method that recognizes the associated damage. It really is amazing, right? That the Gemara recognizes all these different aspects of what happens when somebody's damaged.
Today,
exactly, 100%.
Right.
Pain and suffering. Correct.
Clear your name.
Correct. Well, and the fact that if you do damage somebody, we make people pay for pain and suffering. That's exactly what we're talking about. 100%. And lost wages and doctor bills. Each of these elements has, of course, their core aspect in today's world. Okay. So that was ruling number 2 for today. Now we have ruling number 3 for today. So now we're going to deal with somebody who puts a burning coal on somebody. So v'amar Rabba haniach lo gacheles al libo v'meis pater. If you put a burning coal on somebody's heart and they just go and they don't remove it, then and they die, then you're not liable. You're not going to be prosecuted for killing somebody. But al bigdov israf chayiv. But if you put it on their clothing and they don't do anything about it and their clothing burns, and now they come to you and say, listen, you have to pay for my clothing. Even though they might have been able to remove it and reduce the amount of damage that was done, you're still going to be liable for the full amount. As Rashi says, if we take a look, alibo the mate pater. That you're it's 1, 2, 3, 6, 10 lines up in the Rashi. Shahayalo Lisalka, the man, the reason that you're not obligated for killing is because the person has intelligence. A person with intelligence. If I were to put a burning coal on you, would you remove it? Yes, of course you would remove it. You don't want to be burned, right? No, exactly. So 100% you take it off. So and yet, okay, so now that's with respect to the burning coal and the killing. But with respect to the garment, we say chayev as we continue in Rashi, daha de lo salka, because even though the person didn't remove it, savar is ba'ine le bedina v'yifrali. I don't need to remove it. I know that you're going to be liable to me, and I'm going to collect the damages in court. And that's okay. We can allow the person to have that thinking. Amarava tarvayo tanani. Both of these ideas, both these concepts, the fact that you're not liable for killing and you are liable for the damage, both can be seen in Mishnayos. Alibo ditanan kavash alav latoka or olatokamayim. When it comes to the person's heart, we have a Mishnah that says that if a killer held the victim down in the fire or in water, so alos misham v'meis, and as a result he wasn't able to escape, and that's why he died. Well, then of course chayiv. Then the person physically killed the guy. So even though he didn't have, the person themselves didn't choke the person themselves didn't put the fire on the person, but you held the person in the fire or you held the person under the water, that's killing. You can't get away by saying, I didn't kill the guy, the water killed the guy. No, you can't do that. However, the chafulatocha or olatocha, but if you throw the person into water and you throw the person into fire, and he's able to get out and he dies, well, then you are not liable. Then putter. Then you're not liable for killing. So if you throw somebody into a kiddie pool that's very shallow and they don't hurt themselves in a way that prevents them from getting out, but for some reason they stick their head under the water and they stay there until they drown, well, then you're not liable. But on the other hand, if you stick the person underwater and you hold them underwater, you will be liable. But this point is that this shows exactly what Rabbah says. You put a burning coal on the person can remove the coal. As a result, there's no liability for the death. You're not going to be chaya for having killed the person. What about the clothing case? Big dough. When it comes to the clothing, Ditzanan, we've got another Mishnah. So the first of these Mishnayos was in Sanhedrin, which makes sense because that's where we're going to talk about murder and the like. But now the second one is going to be from later on in this Maseches, Bava Kamma Tzadik Bet Amud Aleph, Kra es Ksusi, Shavor es Kadi, Chayav. That if I even tell you that you should go ahead and tear my garment or break my jug, then you are going to be liable because I did not tell you that, by the way, I'm not going to sue you. So, but almanas liftor patur. But if I tell you I'm not going to sue you, well, then you're not going to be liable. So the point is just like with the case of the coal, I am not obligated to do anything to stop you from doing damage to me. I can allow you to continue. I can even encourage you to continue to do it, and you will still be liable. Okay, so those were the three cases, and now we come to, and now we ask a related question. So Rabbah asks, by Rabbah, what happens if I put the burning coal on the heart of a slave? Now, Rashi, I think, has a slightly easier read. Rashi says that this is talking about on the heart of the slave, and the slave dies, right? Do we say that the slave is like a possession, and as a result, like the possession of the clothing, and therefore you're going to be liable? Or do we say that no, the slave is like a person with intelligence, and as an intelligent person can remove it, and therefore it's like the body. It's like putting it on the body of the person himself, and he's obligated to remove it. So as the Gemara continues, kagufo dami, do we say that it's like putting the coal on the body of the victim, or vivamono dami, or is it like putting it on his money, namely his clothing? So those are the two questions. Now that's Rashi's explanation. Toso says no. This case can't be about murder. This is just about damages, and the situation is the following: we have a slave that is all wrapped up, so he cannot escape, and now I put the coal on his heart, and the owner of the slave is standing there. Do we say, from the owner's perspective, that he can basically say, listen, I know you're going to pay me for the slave. I couldn't care less about this slave. And so as a result, I'm going to allow the slave to die, and you'll just owe me? Or do we say that no, it's just like a garment, and in which case it's just like a garment? Or do we say no, it's a person, you're not allowed to do it? He wouldn't be allowed to just allow that to happen. So that's the Tosos and Rashi's debate. But the bottom line is imdim zalomer kagufo dami shoromahu. So and the Gemara then asks a follow-up question, or Rabbah asks a follow-up question. Not only if let's assume that we're treating this person like a person, meaning you can't just let him to die according to Tosos, and the slave himself would be obligated to remove the coal, because heck, he's intelligent enough to remove the coal according to Rashi. So let's assume that that's the case. Well, now what happens if I put the coal on an ox? Do we say that an ox is intelligent enough to remove the coal, or do we say no, an ox is more like the garment than clothing? So hadar pashta. But Rabbah then answered the question, and what did he say? Abdo kagufo shora kamamono. That putting a coal on the slave is like putting it on somebody's body, and as a result, according to Rashi, it's got to be removed by the person, and you would not be liable for death. And according to Tosos, it's like it also, you would not be liable for the damages, and so as a result, the person would need to remove it. But when it comes to the ox, then we're going to say no, an ox is like property, and so as a result, even though an ox has some level of intelligence, any damage that happens to the ox as a result of the coal being put upon it is going to be subject to liability. Okay, so we have now dealt with okay. Mark, can you give a hand downstairs? That'd be great. All right. So see you soon, guys. So next is we have been dealing with, in this chapter, the second chapter of Bava Kamma, we have been dealing with Regel and Shane. The concepts, see you later, Mark. The concepts of walking, damage done while walking, and damage done while eating, meaning for the benefit of the animal that's doing the damage. Now we're going to turn to bore, to damage in public property, that of things that you leave in public property or create in public property that should not be there. So let's take a look at the beginning of chapter 3. So of Bava Kamma. So hamaniach es hakad b'rishos harabim, if you put down a jug in rishos harabim, uva achar v'niskala ba ushvara, and somebody else trips on it and breaks it, patur. The person who tripped on it, person B, who tripped on it, they're not going to be liable. We'll see why not. I thought we just said in the last Mishnah that Adamu la'olam, so why shouldn't he be liable for breaking it? We'll see the answer to that in the Gemara. Ve'im hu zakba, and not only that, but if person B, the second person along, was damaged by it, Bal hachavis chayev benizko, the owner of the barrel is obligated for the damage. Now, you might have caught in my restatement of the Mishnah that I began by talking about a jug, kad, but I ended by talking about a chavis, barrel. So the Gemara asks the obvious question: pasuk b'chad, v'siyim b'chavis. You began by talking about a kad, but you ended by talking about a chavis. So what is it? Is it usually a kad is a jug and a chavis is a barrel? So utna nami, and not only that, but we have two other mishnayos in Maseches Bava Kamma. One is on Daf Lamed Aleph, and one Amabet, and one is on Kuf Tet Vav Amud Aleph. But these two Mishnayos also have a change where you begin by talking about one object and you end by talking about another. Utnan Nami. Zeba b'chaviso, one's coming with their barrel, the zeba b'koraso, and another's coming with their beam. The nishbera kado shel zeh b'koraso shel zeh. And now, when we're referring back to the chavis, to the barrel, we refer to a jug, and the jug broke with the other one's beam. Putter. Well, then we say that the person who owns the beam is not liable. So puzzle b'chavis v'siyim b'kad. We began with the chavis and we ended with the kad. So again, that seems to be odd that we start talking by one and we learn and then we talk about the other. Utanan nami, and we got another one. Zeba b'chaviso shel yayin. One is coming with their barrel of wine. That's the barrel that won't change. Zeba b'chado shel dvash. One is coming with a jug of honey. Nistika chavis shel dvash, and now the chavis shel dvash, the barrel of honey, it cracks. And the one who had the wine spills out the wine and saves the honey in it. Meaning the point, ain lo elascharo. He's only entitled to his fee. He doesn't get the bottom line is he's not going to get the value of the wine that he lost. He's only going to get the value of the work that he's effectively done to save the honey. Honey, presumably in this case, is more valuable than wine. So pasuk again, but the substance is not as important as the fact that we switched from a kad of honey to a chavis of honey, and so pasuk b'kad v'siyim b'chavis. So why do we make these changed in languages? So Amar of Papa hainu kad hainu chavis. The bottom line is that the Mishnayos are telling us that a kad and a chavis are really the same thing. Well, my nafkamina, why do I care whether they're the same thing? So for buying and selling. So the point is that if I were to sell you, and Rashi makes this point, blast Rashi on the daf, if I said shebiyad hamocher lateit lo eza sheyirtza. If I say that I'm going to sell you a kad, or I tell you that I'm going to sell you a chavis, and I give you the other one, then that's okay. Even if I were to say chavis, the mashma gedola. And nose and lo kad shahay katana. If I say chavis and I give you a kad, and now you're like, I thought you were going to give me a big barrel, and I gave you a small jug. It's like tough luck. You need to be more careful because we know that there are people who use that language of wording, and so as a result, you are going to be out of luck. So, heichidami, what's the story? Meaning, who's the language? Are we talking about a place where nobody uses the language, some people use the language, or everybody uses the language? So heichidami, ilem ba'asra dekada lo karu chavis lo karu chada. If you're talking about a place where nobody calls a kad a chavis and nobody calls a chavis a kad, well then halo karu la. That's just theft if you were to switch, because nobody in the place actually calls it that. So it can't possibly be referring to a place like that. But so lo tzricha. So as a result, we're saying no, that's not the place. Rather, the place where we need to say it is deruba karol kada kada v'chavisa chavisa. Most people call a kad and a chavis a chavis. But the economy de karol chavisa kada kada chavisa. But there are some people who switch those language up. So ma'odema zil basaruba. I might have thought, as we now turn to Kav Zayin a bit, that we should just follow the majority. After all, there are so many times in halacha that we just follow the majority. The Kamash Malan comes to teach us a very important principle that is a key principle for us to understand. We are not going to follow the majority of the situation when it comes to money. And so as a result, Rashi helps us out here. So when we have a milsa, when we have some kind of case that we're uncertain about, like this case, right? We don't know what was intended. We could say, well, listen, most people call a chavis and a kada. So as a result, when you said you were going to give a chavis, you need to give a chavis. And we could just go follow the majority. Or what about a case where a person sells an ox, and it turns out as we'll see in a couple of weeks, because it's on Daf Mem Vav, that it's a goring ox. It's an ox that loves to gore. And so as a result, it's going to create tremendous damage if you try to use it either as a plowing ox or as a transport ox. And so I might have thought that the buyer in that situation can say, listen, most oxen that are bought as a plowing ox or a transport ox. And so as a result, you sold me something that's not fit for the ordinary usage. And as a result, I want my money back. So lo amrin and basa rubazil, but we say we don't follow the majority. Ulacharisha kano, and that the person is buying it in order to do plowing. Vahavi taos, and therefore it's a mistaken sale that you should be able to undo. Ella amar hamotzi michavero alavarai. We say that no, you need to prove that that the seller knew that it was being bought for that purpose. The yachol omar lo, because the seller could say to the guy, I sold it to you so that you could shech the animal and eat its meat. I did not intend for you to buy it as a working animal. So that's the story, and that's the situation. And so now we say, Ein holchen achar b'mamon achar haro. So now we go back to our Mishnah, and our Mishnah had said that there was no liability for person B who fell and broke the jug or barrel. So now the question is, why not? Patur. So a person came and he tripped on it and broke it, and now he is exempt. Amai patur. Why should he be exempt? He should look where he's going, and in order to avoid tripping on something. So Amrei Devei Rav Mishmei de Rav. So they taught in the Academy of Rav, according to Rav, B'memale Rishus Harabim Kula Chavias. We're talking about a situation where there was no escape. Basically, the entire Rishus Harabim was filled with this person's jugs. There was just nothing to be done. You needed to be able to go through. There's, it's an interesting question how this applies today, right? If somebody's blocking the road and you try to get by them, are you, who's liable in that situation? But the bottom line is, we're talking about a situation where the entire Rishus Harabim, the entire public thoroughfare, was filled with pitchers, and so there was no way to escape, and that's why he tripped on one and broke it. That's not the only answer, though. That's answer number one. We're going to give 4 different answers. Shmuel Amar Ba'Felushan. We're talking about at dark, and so as a result, he didn't see it. Rabbi Yochanan Amar B'Keren Zavis. Rabbi Yochanan says, no, we're dealing with it was at a corner. And so Amar of Papa, Lo Daika Masnisin, Ella Oka Shmuel, Oka Rabbi Yochanan. Now, when you take a look at the wording of our Mishnah, it makes more sense like Shmuel or Rabbi Yochanan. Because the Rav, when it comes to Rav, my area Nisko, we said specifically that the person stumbled and tripped on the jug. Why did we need to say that? He could even afilu shavar nami, even if he intentionally broke it. Meaning, the point is that you're not allowed to effectively jail somebody by saying, "Oh, you can't do damage to me." Because you can't go anywhere, because anywhere you go, you're going to move and break something of mine, and so as a result, you're stuck where you are. That's not. We don't allow people to do that, and so as a result, the person who's stuck is allowed to move in an ordinary way and even break things deliberately, because he's been essentially stuck in his place. So Amarav's vid mishmei derava hu adin dafilu shabar. No, the truth is that we could say that our Mishnah, it does allow for the possibility of being even like the Debay Rav Mishmei de Rav, the yeshiva of Rav in the name of Rav, and that and really you could break the pitchers deliberately. V'hai de katani nisko. But the fact that we talk about a tripping case is Aidi Dubai Lemisne Seifa, is because of the end of the Mishnah. Because what did we say at the end of the Mishnah? The Imhuzakba Balchavis chayav benisko. That if in fact the pedestrian got hurt as a result of the pitcher breaking, well then the owner of the pitcher is going to be chayav for that damage. Dedavka nisko, because that damage is only obligated if the person actually tripped on it and broke it and not intentionally. Because aval shaver low. Because if in fact the guy broke it intentionally, he would not be liable. Because my timahu de azik, he damaged himself, right? His breaking it intentionally, even though he has justification for doing it, it is essentially on himself. So Katani Resha Nisko. So as a result, because the damage that would be paid by the owner of the jug to the pedestrian who trips is only true if he trips. That's why the Mishnah also opens with the language of tripping. Okay, so Amrle Rabbi Abba Rav Ashi, Hachi Amri b'Ma'arava Mishmei de Rabbi Ula, and that's exactly what they said in the name in Israel in the name of Rabbi Ula. Lafisha ain't darken shall ben. Oh, I'm sorry. And now we have a fourth answer. That the following is the explanation given in Israel in the name of Ula. Lefisha ein darken shall b'nei adam lisponein b'drachim. That in fact the people don't have a way, it's sort of like with your phones, right? People are on their phones; they're not looking where they're going, and they bang into things. That people don't actually look on the way, where they're walking, and so as a result, that's why that would be okay. And Hava Uvda Benarda. Now there was actually in a situation in Naharda, V'chi of Shmuel, and Shmuel said that the pedestrian had to pay for the broken item. And Pumbedisa, V'chi of Rava, and there was an obligate situation in Pumbedisa where Rava made the person pay for the broken item. So Bishlam Shmuel Kishmaite. Now Shmuel could just follow his own teaching because he says that the reason that there was no liability in our Mishnah is because it was dark. And so all he has to say is we're talking about a situation where it was light. But El Rava, Lema Kishmuel Svirle, well, when it comes to Rava, do you want to say that it's actually Shmuel, that he really agrees with Shmuel's interpretation? We don't have to do that. Amara Papa, no. Karna de Atzrahavi. We could talk about a situation where it was a corner where it was of an atra, of a press, and so as a result, the kavan de brishus ka'avdi, in a corner near a press, you're allowed to put down barrels, meaning that there are some places in the public thoroughfare where people can expect to find jugs and barrels, and if you break something in those places, you are going to be liable for it. That's a situation where you're going to have to pay, and we're going to expect people to watch where they're going. So even according to that last approach, where we say that people don't ordinarily watch, people are obligated to watch when you're in a place where people are going to be where people are allowed to leave things. And so as a result, as you sort of, in some ways, I sort of think of this as a person's walking on the sidewalk. As one approaches the street, one is obligated to look up because people are expected to be standing in the corners, at the corners, waiting for the crosswalk. Exactly, and in the crosswalk. And so they're, not necessarily in the crosswalk. In the crosswalk, hopefully they're walking, but at the corner, waiting for the light to change. Exactly, that's where they're going to be naturally standing. And so as a result, you bang into somebody there, even though we might ordinarily say, people don't look where they're going. But people need to look where they're going when you get to a place where people are going to be standing. So, all right. So that is that situation. So now the Gemara is going to turn, and with this we will conclude for today, to the question of when can people take the law into their own hands. And we will not finish this issue today, so you can already guess what my teaser is for tomorrow. So Rav Chisda asked the following: Sholach le Rav Chisda le Rav Nachman. He asked Rav Nachman, "Harei amru l'rechov shalosh." With the following rules exist with respect to embarrassing, that if you hit somebody with their knee, you have to pay 3 selah. Levi'ita chamesh. If you kick them, you have to pay 5. L'sonokeres shloses, right? And if you hit somebody with a donkey saddle, you have to pay 13. These are the payments for embarrassment. Lefanda demara ulakofina demara mai. But if you hit them with a shovel or the blade of a shovel, then what's the story? I realize I got this wrong on my sheet. I'll have to change it. But the point is, the question is about the handle of a shovel or the blade of a shovel, not the donkey saddle. But all right, so sholach chista kanasa magbes Bava. 1 second. We know that outside the land of Israel, there were not expert judges, and so as a result, you were not allowed to charge. Judges were not allowed to address questions of kanasos, of penalties. And so the question isn't this considered like a penalty? Now, it's not an actual penalty, but the point is that it's similar to a penalty. So Emily Guva de Uvda Hechihav. So tell me what really happened here so that I can understand what the facts are. So Sholach, so Rav Chisda responded back, Dahu Gargusa de Betre. There was a water cistern that was owned by two people. And every day, one of them got to pick the water out, draw the water. One of them, we'll call it person A. Person A comes and takes it in person B's day. Amrle, person B says to him, Yoma Dideyu, it's my day. How can you take away my water? Lo ashkachve. And person B says, no, I'm sorry, I'm not going to pay any attention to you. And so the other person takes the handle of the shovel and he hits him with it. Okay, so what's the story? So Amrle, Rav Nachman says back, he could have hit him 100 times. Now, it's important to note that we're assuming that the only damage is the embarrassment associated with it, not actually physical. At least that's the way I'm understanding this at the moment. Because even according to the one, and Rav Nachman says, and this is true, even according to the people who say that you're not allowed to take the law into your own hands, because b'makom b'pseida where you're going to suffer a loss, you're allowed to take the law into your own hands. So De'idmar, because we have the following machlokas between Rav Yehuda and Rav Nachman himself. Rav Yehuda Amar lo avid inish dina l'nafshe, a person is not allowed to take the law into his own hand. Rav Nachman Amar avid inish dina l'nafshe, a person is allowed to take the law into his own hand. Heka de'ikab say the kuli alma lo pligi, and when there is a loss, everyone agrees, David inish dina l'nafshe. Everybody agrees you're allowed to take it into your own hands. Ki pligi, where do they argue? Heka de'ikab say that where there's not going to be a loss if there's a delay in enforcement of the law. So Rav Yehuda Amar, Rav Yehuda says, lo avid inish dina l'nafshe. In that situation, you're not allowed to. Why? Listen, there's no loss. You can wait until the judge takes action, and as a result, just go lezel kameh diana, go in front of the judge. Rav Nachman Amar, no. A person is allowed to enforce the law for themselves. Kaven din of it, because he's acting according to the law. Lo tarach, he shouldn't have to go through the trouble of going before a judge. And so, as a result, we have this machlokus. Now, tomorrow we're going to begin with Rav Kahana's challenge to Rav Yehuda, but for that you'll need to stay tuned for tomorrow's daf, and an interesting issue of when can you take the law into your own hand. All right. Have a wonderful, wonderful day. Look forward to continuing our learning together.
Yasser Khan, thank you. I've been on a bus the whole time.
All right. Be well. Bye-bye. Travel safely.